Good afternoon, everyone. Thank you once again for joining us here at the ABA's Division for Public Education Twitter feed. As always, I am pleased to be joined by Professor Stephen D. Schwinn of UIC John Marshall School of Law. Professor Schwinn, thank you once again for joining us.
It's a real honor, Kathy. Thanks for having me.
So we are just going to touch base on a couple of loose ends as 2020 winds down to its end. And I wanted to start off by giving us a chance to reflect on Trump versus New York, the census case. When last we spoke, we were getting ready for argument on that case. And I think you and I were both anticipating having had a decision by this point and having an opinion we could dig into. So Professor Schwinn, what happened in argument in that case? And what do you think it means that we don't have a decision at this point in December?
Yeah, those are great questions, Kathy. So just a real quick recap. This involves the memo that President Trump issued last summer, directing the Secretary of Commerce to issue not only the total head count with the census numbers before the end of the month in December, but also a separate count of unauthorized non-citizens to go along with the total head count. Now, the idea then was that when President Trump certified the allocation of seats in the House of Representatives to Congress, that he would discount the total count in the United States by unauthorized aliens, which, just again, to remind listeners, that's unprecedented. We've never done that in our country's history, and it flies in the face of the plain text of the Constitution and statutory law on how to count heads in the census and how to allocate seats in the House of Representatives. So this was a real big deal. The case went to oral argument, and the Supreme Court, I think, expressed some concern about the case on a lot of different levels. For one, the Trump administration was utterly unclear about how and when it could report any numbers to the president, and in particular, how and when it could report determinate numbers on the number of unauthorized non-citizens in the United States, and even indeed whether it could do that. And a number of justices on the court expressed deep concern about that. Moreover, there are other issues involved in the case, just sort of how to sort it out in general. But the big problem in the case is the timing, right? I mean, the timing here is really, really strange. So we don't know if the secretary is going to be able to report numbers before the end of the month, as is required, and as the Trump administration has said at one point that it would do. We don't know if that's going to happen. We don't know if numbers on unauthorized non-citizens are going to come in before the end of the month. And so we're in this kind of weird limbo with regard to the administration reporting numbers to the president before the end of the month, whether that can even happen, much less whether it's a violation of the Constitution and statutory law. Big surprise in not getting an opinion in the case yesterday, which was the last scheduled date for opinions by the Supreme Court before the end of the year. The end of the year, again, being the deadline for reporting these numbers. We expected a decision yesterday, and we may yet get a decision if the court adds a decision date to its calendar. But the fact that the court didn't say anything on this yet, I think, is a big question mark. I am not quite sure we know what that means.
Yeah, I think you're spot on. I think the timing of this case was interesting to begin with. Even when we had argument right after Thanksgiving, it was both too late in that the census count had already happened, but also too early in that the reporting of these numbers hadn't happened. So there was some question about whether there was any actionable harm yet for these individuals. And it was a really interesting place. And I think that was one of the things you really saw the justices struggling with during the questioning, was sort of how do we deal with this, where this case is currently and what's happening in the mechanisms of the census reporting. And the longer we go without a decision on it, the timing gets even more interesting. And I just don't know what sort of decision we get from this court at this point on this question.
It's very, very strange. I think you're spot on in your description. Now, with the Biden administration coming in on January 20th, I don't expect that a President Biden would certify census results to Congress minus unauthorized non-citizens. Again, so that would be an unprecedented thing to do. It was uniquely Trumpian, and I don't expect that a President Biden would follow suit. Still, if the numbers are reported before January 20th, President Trump will have authority to issue those numbers to Congress. And so again, just kind of underscoring the weirdness of the timing. Kathy, one of the things that's really frustrating to me about the case, I think both frustrating and really exciting, is that the timing issues, the standing issues, other sort of technical issues in the case are preventing us from having a real hard discussion about the underlying merits. And I think this is what we might do in, for example, high school civics classes, right? The Constitution and federal statutory law provides that everybody in the United States, including unauthorized non-citizens, so long as they regularly live here, ought to be counted in the census and ought to be counted toward congressional representation and other things like federal funding that's tied to numbers in states and local jurisdictions. I think there's a really interesting discussion here about what it means to be counted in the census. Remember, President Trump's position was he sort of had this theory of democracy that unauthorized non-citizens shouldn't be counted in the census because they're not citizens, right? On the other hand, we've always counted them in the census because representation reflects the number of people in the country, not just citizens in the country. So I think there's a real interesting discussion and debate to have around those issues.
Yeah, I think it's interesting. A lot of the sort of education you saw around the census, both as like a public service announcement, why it's important to fill out your census, but also a lot of the work that teachers were doing and talking to their students about using this opportunity as a learning exercise. Why is the census important? What does it mean to be counted? What does it mean to be a citizen, both in the I hold a passport, but also my I live here sense of the word. And I think you're right that some of that is getting lost in this really procedural, nuanced arguments around this case, and we are some folks are losing sight of these questions.
That's exactly right.
Yeah, I think the case provides a really interesting opportunity for teachers or students to dig into some of these questions and what does it mean to be counted and who gets to decide who gets counted. Also, I think is really interesting.
Absolutely. And it goes back to old questions like, they go back to the founding of our country, no taxation without representation, right? I mean, we've always said that people ought to be represented in Congress if they're governed by Congress, if they're taxed by Congress. And that includes unauthorized non-citizens as well.
Yeah, I think some of the argument, although it was a really sort of strange argument for a lot of reasons, reflected on the idea of the 3/5 compromise, on Native Americans and the history that they have with the Constitution. And you see some of these really fundamental questions of who the Constitution covers or doesn't cover were interwoven into the argument and can maybe be pulled out in some of those discussions.
Spot on. Exactly.
Yeah. So, Steve, talking about strange cases with interesting questions about jurisdiction and court procedure. Since we last chatted, we had the court sort of coming in at the 11th hour on the case out of Texas, looking at the federal election and a strange case involving the court's original jurisdiction doctrine. Questions about federalism. Can you talk to us a little bit about the Texas versus Pennsylvania election challenge and what we learned or didn't learn coming out of that opinion?
So much to say about this. And let me just start by saying that it shares this characteristic with the census case that we can get tied up in knots about the procedure and the sort of what we call technicalities. They're not really technicalities, but technicalities of the case without coming to the harder questions underlying the merits. And so I think we can talk about those. You and I, but also in high school civics classes, for example. So this was a case where Texas sued Georgia, Pennsylvania, Michigan, Wisconsin in the Supreme Court directly under what we call the court's original jurisdiction. Now, we tend to think of the Supreme Court as an appellate court, hearing only appeals, but as it turns out, it also hears original cases when one state sues another state and in some other special enumerated instances. But here you had Texas suing some other states. And so Texas claimed original jurisdiction at the Supreme Court and went ahead and filed directly with the Supreme Court, treating the Supreme Court as a trial court. Texas's claim was that those states, Georgia, Pennsylvania, Michigan, Wisconsin, that they violated the electors clause in the Constitution. Now, here's an interesting claim. What they said is the electors clause in the Constitution provides that state legislatures, and it uses that language, legislatures, the legislature of the state has the power to direct the way that electors are appointed in the state's electoral college. Now, all of these states have already done that. What they've done is put a law in the books that says the majority winner in the state gets the state's electoral votes. But what happened in these states is that state courts, state executive officers, they made some tweaks to state election law in order to accommodate the COVID pandemic and voting in the COVID pandemic. And what Texas was saying is, look, when the state courts or when state executive officers make changes to election law, what they're doing is essentially taking the power away from the state legislature to direct the way that electors are appointed in the state. And that violates the federal electors clause. Now, that's an interesting claim. I think most commentators, and I agree, think it's a wacky claim, but it's an interesting claim and one that we could have a serious debate about. But we didn't come to that. And the reason why is because the Supreme Court ruled in a very, very short opinion that Texas lacked standing to bring the suit. What the court said was that Texas didn't assert the kind of personalized direct injury that was caused by the actions in those states and could be redressed by a court ruling in order to punch its ticket to get into federal court. And so the court dismissed the claim. So again, we're left with a ruling on standing, a kind of, you might think of it as a procedural technicality. It's actually really important, but nevertheless, we don't get to the underlying merits in the claim. Now, again, most people think the underlying merits just don't have any there, but still the court effectively dodged the electors clause claim.
Yeah, I do wonder if this is an issue that we're going to see come up to the court on a better case, as you would say, in this sort of avenue, meaning a case where it's a little bit more obvious as to the procedure to get it before the justices. I think we saw some of this thread of argument in the Pennsylvania mail-in voting case, which the court also sort of kicked out on a procedural issue at that point, or held over on a procedural issue at that point. And I think we've already seen some changes happening with State Board of Elections as to what their plans are going to be for elections going forward, that could potentially bring up some of these challenges that we may get it down the road. Although I do think we've seen this as a court that's been pretty hesitant, at least in this election cycle, to really, give big arguments and long times and a lot of briefing to some of these election challenges. They've really sort of been playing whack-a-mole with some of these election challenges as they get to them. So I do wonder if on different facts in a different election, what this court does.
Yeah, I think all your points are spot on, Kathy. And it's interesting because right after the Supreme Court ruled on Friday, the Trump team came out and said, well, okay, so Texas doesn't have standing, but individual voters and President Trump himself would have standing in these states to lodge the exact same claims against the states in individual suits. And so we started to see the Trump team actually move in that direction. And as it turned out on Saturday, we had a district court ruling in a case that President Trump brought, lodging these exact same claims, but rejecting them. What the court said was, look, the state legislature delegated authority to executive officers to make changes to state election law. And so when President Trump says that violates the electors clause, well, President Trump is flat wrong about that because the legislature already did that by delegating the authority to executive officers.
Yeah. Steve, before we sort of put to bed at least this current election challenge, could you talk a little bit about what the vote actually was? I think there was some discussion or nuance about, was this a 7-2? Was it a 9-0? And I know, at least for me, someone who spends some time editing articles on the water law cases and original jurisdiction cases, it provides some insight actually into what the court thinks about these cases. So why is that 7-2, 9-0 distinction important, and what does it mean?
Yeah, so just to be clear, it was 9-0 in the sense that 9 justices agreed to dispense with the case summarily without getting to the merits. 7 of the justices said the state lacks standing. 2 justices said, in cases of original jurisdiction, the court's jurisdiction is what we call mandatory. The court has to take up the case when a state sues another state under the court's original jurisdiction. 2 justices' position was that when that's the case, we've got to hear it, right? Now, what that means with regard to standing, does it mean that the court also has to hear the case if the case lacks standing? Well, I think that's an interesting question. Under mandatory jurisdiction, and if the court were to be required to take up the case, then we might read those 2 justices' opinion as saying, yeah, we're required to take up the case, but we don't think it has any merits, and so we're going to dismiss it. So there is this kind of debate about whether it was a 9-0, 7-2 decision, which I think is interesting. And you're exactly right to say that that sometimes telegraphs the way the court's thinking about cases in original jurisdiction matters. And I think maybe here around the edges it might as well. But at the end of the day, what we have is 9-0 ruling, flatly getting rid of the case. And I think what most commentators have said about the case is exactly right, that this was a flat and bald rejection of these really hyper aggressive claims lodged by Texas.
Yeah, for sure. So just before we close today, any reflections or thoughts on what we learned about the Supreme Court in 2020? I know we've learned a lot about ourselves, but how we can work from home. What do we know about the court as we look forward to 2021?
Wow, great question. It might be a little too early to tell. The old saw is that with every new justice, there's a new court. And so, of course, we had Justice Ruth Bader Ginsburg unfortunately die this term, and replaced with Justice Amy Coney Barrett. That's a significant, huge change on the Supreme Court, but it might be too early to tell exactly what it means. Kathy, my own thought, listening to the arguments and watching what the court's been doing is, and knowing a little bit about Justice Barrett's jurisprudence, I think this court is going to lean even more in favor of religious rights than it has in recent terms. This has been a long trend on the court, but I think it's now coming to a head where the court's going to start to rule pretty aggressively, even more aggressively with regard to religious rights. We talked about the Fulton case in a different episode, and I think that's one to keep an eye on. The court also ruled last week that there's an individual cause of action in the Federal Religious Freedom Restoration Act, which I think is consistent with this trend. And I think this is something that we need to keep our eye on. Other than that, there are a lot of predictions about the way Justice Amy Coney Barrett is going to change the court, and will undoubtedly change the court dramatically. But I think it may be too early to make any firm predictions in other areas. What do you think?
I think that's really accurate. I think this was a court we still didn't really know that well, even before the passing of Justice Ginsburg. We'd had two justices come on in the relatively near recent past for the Supreme Court purposes. And we were still sort of feeling a lot of that, feeling Justice Gorsuch and Justice Kavanaugh out and really getting an understanding of what their jurisprudence as a Supreme Court justice was going to look like. So now you add a third new justice onto the bench. And I think there's just a lot of unknowns as to how these are going to play out. For me, the big reflection on the court as I'm thinking about 2020 is sort of how I tend to say in general, this is a court, Chief Justice Roberts doesn't love the court to be in the headlines, doesn't love the news to sort of the media and the political debates to filter into the courthouse necessarily. And this is a court that's had to face that this year, right? They had to move to telephone arguments. They had to respond to the pandemic in their own ways, both sort of procedurally and day to day. But then they've also had a lot of cases before them that have really been about recent ongoing, the pandemic, political debates, even the cases we've talked about today. The census case was before them because of the way the pandemic forced the census counting to shift and the timeline of that to shift. Some of the voting challenges were for them because of the way the pandemic forced voting changes at the local level. So I think this is a court that has in the past really tried to remove itself from sort of ongoing current events. And as we've all learned, you can't remove yourself from COVID-19 and what that means in our communities. And that we're really seeing them sort of struggle with that and both day to day, but also really big picture. What does this mean for how we run our democracy? What does it mean for how the Constitution responds? And for me, it's been really instructive to think about how the Constitution and the rule of law responds in a time like this. And all these different ways beyond a health issue, a public health issue that bleeds into voting, census, prisoner rights. I think we're going to see maybe some challenges to that coming up as it relates to the pandemic and perhaps vaccine rollouts, all those sorts of things, and how the rule of law, does it have elasticity in this area, and how does the court view its role in those debates, I think is really interesting, and I think something we're going to be reflecting on for decades to come.
I think that's really insightful, and it gives us an opportunity in our classrooms to talk about the judiciary's role on the separation of powers, right? Is the court striking the right balance when it tries to stay its hand from these hot button political issues? Or should it get involved? Must it get involved, as you correctly said, in so many of these issues? And if it does get involved, how? What's an appropriate role for unelected justices in our separation of powers system?
Yeah. Well, Professor Schwinn, it's been an interesting year. I'm glad we started these at the start of the term. I look forward to continuing them perhaps over the rest of December if we do get a census ruling, and certainly into 2021 as we see what happens with this court and the challenges before it. So thank you, as always, for joining us. I really appreciate your time.
Well, thank you, Kathy. It's been a real pleasure.